Great. Okay, welcome everybody. The first item on the agenda is the minutes from the April 5 board meeting. Some people had a chance to review. I don't know if there are any comments. Nope. Need a motion then?
Motion to approve.
Second? Okay. All in favor?
Aye.
Any opposed? Nope. Okay, those are adopted. And then we're off to the overview of the fiscal year 24-25 budget. Burton?
Yep, good morning, everybody. When we last met at the April meeting, the state budget had not yet been passed by the state legislature and signed by the governor. So we are now able to provide you with an update of what the final enacted budget looks like for ILS. The all funds budget for ILS in the final enacted budget was just over $474 million. That's an increase of $5.9 million above last year's enacted state budget. And as you know, we've discussed in the past, ILS's budget really kind of breaks down into two buckets. Our state operations funding, that's the funding that funds the personnel and technology and equipment and office space for our office, as well as our aid to localities funding, which is the funding that flows through ILS and is dispersed to the counties. For the state operations budget, the final enacted budget was the same as what was proposed in the executive budget back in January. That is just under $8 million, which is an increase of $958,000, which will allow ILS to create 3 new positions. Bolstering our grants unit, and that funding will also account for a 3% general salary increase for all ILS staff who are on payroll as of the end of March 2024. So that was our state operations appropriation. For our aid to localities funding, it's best to think about this in terms of the 5 different aid to localities programs that we have. The first of which, ILS distributions and grants. The final enacted budget had an appropriation of $81 million. That was the same amount as was proposed in the executive budget. It's held flat from fiscal year 23-24, and that did not include the 3% cost of living adjustment that we were seeking to that program, as well as a couple of our other programs. For the implementation of the Corral herring settlement, we ended up at $23.97 million. That final enacted amount is the same as what was in the executive budget proposal back in January, and it represents an increase of $160,000 over last year's enacted budget due to additional funding that was provided as part of an agreement between the Corral herring settlement parties for an additional attorney position for the Schuyler County Public Defender Office. Similarly, that funding did not include the 3% cost of living adjustment that we were seeking for that program. The third of our 5 programs, the extension of Corral herring reform statewide, that came in at $250 million. That's the same amount as was in the executive budget proposal. That is also held flat from last year's final enacted budget. Similarly, did not include the 3% cost of living adjustment that we had been seeking for that program. For the family court representation parent defense funding, we ended up with a final enacted budget, a final enacted appropriation rather, of $19.5 million. That's an increase of $15 million over the executive budget proposal that was released in January. And it's an increase of $5 million over fiscal year 23-24, last year's enacted budget. It is short of the $50 million that we were seeking, as we've discussed in previous meetings. But thanks in part to support from the legislature, we were able to end up ahead of where we started in January when the executive budget proposal was released. And Patricia will be talking more in her discussion of our allocation plan for our funding, what the thoughts are on how we will disperse that additional funding this year. And then finally, in terms of those 5 programs that compose our aid to localities budget, the assigned counsel program rate increase reimbursement program, Once again, the final enacted budget was the same as the executive budget proposal, $92 million. That is also the same as what was in last year's enacted budget, and that will continue to provide some fiscal support to counties in New York City for the increase to the statutory assigned council rates that took effect last year. Stepping outside of ILS's budget, the Unified Court Systems budget, once again, included an appropriation of $47 million that is ultimately suballocated to ILS for dispersing to New York City for implementation of caseload standards for institutional providers of mandated criminal defense. So we will be dispersing that funding as well this year. And the final budget also did include the language that we discussed at the last meeting proposed in the executive budget to authorize the division of budget to transfer up to $234 million from the Indigent Legal Services Fund to the state's general fund. It's our understanding that up to $114 million of that authorization is to account for the state's reimbursement to counties in New York City for 50% of their expenditures related to the increased statutory assigned counsel rates, as well as the increased attorney for the child rates. So that is sort of the picture for us in terms of the final enacted budget, and I'm happy to entertain any questions.
We think the whole 234 million will be swept.
You know, it's hard to say at this point. What we can say is last year's final enacted budget did include authorization of up to $114 million, which again, we understood to be related to the assigned counsel rate increase and attorney for the child rate increase. And what we saw at the end of last fiscal year was a transfer from the Indigent Legal Services Fund to the general fund that appears to very closely mirror what was actually claimed out for the increased assigned counsel rate. So in other words, they didn't use the full transfer authorization last year. Whether or not that's indicative of this year remains to be seen.
Thank you. Anyone else? Good. Thank you, Bert.
Yeah.
So the next item will require a vote. It's the allocation of the 24-25 aid to localities.
So pursuant to Executive Law 833-7, it is the board's responsibility to vote on and approve an allocation of how we disperse the aid to localities appropriation that Burton just told us about. And so in your board materials includes a letter with some attachments describing our proposed allocation plan. And I'm going to walk through that plan right now to give you an overview and also an opportunity to ask any questions you may have. And I'll go through the plan program by program. As Burton described, the ILS aid to localities budget is essentially broken out into 5 distinct programs. The first program is what's called the ILS program, and that's the appropriation of $81 million. And that $81 million does basically 3 things. One, 40 million of it has to go to New York City pursuant to the state finance law. It's what we call the statutory disbursement to New York City. So that leaves us with $41 million. And what we propose is that 30.2 million of this be used for ILS distributions. And so how that works for the ILS distributions is essentially 7.361 million would be for the 3rd year of distribution 13. 15.5 million would be for the 2nd year of distribution 14. And these are contracts that have already been issued to the counties. And then 7.36 million would be additional funding for distribution 14. In other words, it would add funding to distribution 14. Now, this amount would be what we would usually be for the 1st year of a new distribution 15. But this year, we're proposing that instead of issuing a new distribution, we add money to an existing distribution contract. Why? Because it's Currently, right now, the way we do distributions, every county has 3 distribution contracts at once. And what we're trying to do by adding money to distribution 14 instead of issuing a new distribution is consolidate these 3 distribution contracts into one contract with a full amount of what would be equal to the previous 3 contracts. And so adding money to distribution 14 instead of issuing a new distribution is the first step in that contract consolidation, which of course leads to another question. Why consolidate contracts? There's several reasons to do it, but the biggest one is really contract management. It's been very difficult for the counties and for ILS to manage the multiple contracts that every county currently has with ILS. And this is a first effort to start the process of consolidating our contracts to make it easier for counties and New York City to manage ILS funding. It also makes it easier for us to really follow the money, to understand exactly how every county is spending the money. It's been really difficult to track it when you've got contracts layered on top of each other. And so this is really just sound fiscal management and accountability to do this. And it's something that counties have been yearning for a while. And so, we've already previewed this proposal to the counties, to the public defender chiefs, and they've embraced it. So that's what we're proposing for the distribution part of the 81 million. And then finally, that leaves about 10.8 million for our quality enhancement grants. And that includes several different grants, but the 2 that we propose allocating funding for this year with this year's funding is 7.4 million, about 7.4 million for the 2nd and 3rd years of our upstate quality improvement and caseload reduction grants. And these are 3-year grants. And they fund programs and positions that are foundational to the Harrell Herring settlement implementation statewide and within the Harrell Herring settlement counties. And currently 37 counties have these grants. And then we also proposed 3.4 million for the 3rd year of a 3-year program for the operation of our 6 regional immigration assistance support centers, immigration assistance centers, or our REACs. And we essentially have 6 REACs across the state. It's a statewide network that supports attorneys in understanding and effectuating their professional responsibility under the United States Supreme Court case, Padilla versus Kentucky, to really know of and advise their clients of the immigration consequences of their criminal justice involvement. And we've also expanded that to include advice to attorneys on family court involvement too. Because both criminal legal system involvement and family court involvement can have immigration consequences for clients. And so that funding would be used to continue the REACs. So that's the $81 million or the ILS program. Of course, the second program is the Harrell Herring Settlement Program. And this is the 23.97 million for the 5 Harrell Herring settlement counties. And this funding would be allocated to continue the settlement programs that these counties have implemented so far with settlement funding, starting in 2016, essentially, when they first started getting settlement funding. The one thing about this program is recently we've been able to issue contracts, renewed contracts to the 5 Harrell Herring settlement counties, 1 contract each for all of their settlement programs. Previously, they were managing for their settlement programs 3 contracts. And so, we've consolidated those contracts. They are much relieved. And it did give us, in terms of using the limited funding available and not getting the increase we requested, it did help to have 1 contract with all the programs in it, try to sort of manage some of the fiscal magic in which we had to engage in order to continue full funding for these programs, despite the fact that there's no increased settlement funding. The third program, of course, is the Hurrell Herring Settlement Extension statewide. And that's the $250 million that we had said in 2017 would be necessary to extend the settlement statewide. And again, this would be allocated to the counties to continue, the non-settlement counties and New York City, to continue to build the programs that they need to be in compliance with Executive Law 832.4, which essentially extends the settlement statewide. And so these are the caseload relief programs, the counsel at first appearance programs, and the programs for quality improvement initiatives. And so the funding would be allocated to continue, that progress and implementation. I'm going to skip over the family defense grant funding for a second and go to the $92 million for the ACP rate increase. And again, we propose that this funding be used as we've used it this past year to reimburse counties in New York City for 50% of their expenditures related to the statutory increase in the assigned council rate. And we were able, because of the budgetary language, instead of dispersing this funding to counties via contracts, which would be really difficult for assigned council programs, we were able to establish a certification process whereby counties send us, and New York City sends us a certification of what they sent with some fiscal backup, to back up that certification. And this process so far has worked flawlessly. And I really appreciate Burton and our grants unit and sort of setting this process up and getting it working. And making sure, everybody in the grants unit knows that as soon as we get a certification, they review it. We have a designated person to do that. She reviews it, signs off on it, and she comes right to my office to get the signature. So this funding, we're trying to get this funding out the door as quickly as possible. And so far we've seen nearly all counties are taking advantage of this process, and we're reaching out to the counties that haven't been taking advantage of it so far. So that's all of the programs, except for, I think, what, this board is talked about quite a bit because it's very important, and that's the Article 18B Family Court Representation Funding, or the $19.5 million appropriated to improve the quality of representation provided to parents in family court matters. Now I want to take a step back here and go back to fiscal year 2021 and 22, which is the first year that the ILS 8 localities budget included special funding for improved quality representation of parents in family court matters. And that was a small amount of funding, $2.5 million, and it has increased, not dramatically, but some increases each year since. And each year since, ILS has used the funding to disperse to counties via a competitive process, what we call a request for proposals or RFP process. And we've had to disperse the funding to counties via a competitive process because it's not enough for us to disperse to every county. And so the only way to do it under New York State procurement rules is really that competitive process. And via this RFP process or competitive process, currently we have 3 grant awards. We have the first Family Defender grant, which currently 5 counties are in receipt of. We have the second Family Defense grant, which currently 17 counties are in receipt of. And we have the third Family Defense grant, which currently 7 counties in New York City are in receipt of. So that's currently those counties. So essentially what we propose to do is use the $19.5 million appropriated in this year's budget to essentially do 2 things. One, to ensure that each of the existing grant recipients from those 3 grant awards has full funding for their programs through December 31st, 2027. And to do this, we would need about $6.9 million. Now, page 4 of the letter, with the proposed allocation really fleshes out exactly the details of that. So I won't go over every detail, but I would also refer you to the funding chart that was an attachment, because that's a visual depiction of how we would use the $6.9 million to continue the grants that are currently in existence through December 31st, 2027. It would also mean that $2.5 million that the board had allocated in last year's budget for continued first family defense grant would be reallocated to be part of continuing the funding for these grant recipients through December 31st, 2027. With the first family defense grant funding being increased from $166,000 a year for the grant recipients to $250,000 a year, which is consistent with the amount in the second and third family defense grants. So that would account for about 6.9 million of the 19.5 million. The rest of the funding, or the 13.6 million that's remaining, we propose using to issue another competitive grant, the first family or fourth family defense grant. This one, like the third family defense grant, in the amount of $250,000 a year over 3 years, for a total grant amount of up to $750,000. And we would also, again, this would be a competitive process. But like the third family defense grant, we would exclude from eligibility current grant recipients. So it would enable us to reach those counties, or at least some of those counties, that currently have not benefited from the ILS funding for improved quality representation for parents and family court matters. We anticipate that this would allow us to reach between 18 or 19 counties. So that is,
So what would be the total number of counties that have these services?
would be about 40, 30.
If it's 19 or 20, 49, I think. I was
Yeah,
just doing the
yeah.
addition.
Yeah, well, there's two overlaps, so it'd be about
Okay.
46, 47 counties
Okay.
is what we hope. And that's close to the entire state. But we're hoping that by, putting everybody sort of on fiscal funding through December 2027, because the fourth family defense grant, the term of those contracts would be through December 31st, 2027 as well, is we would have these programs entrenched in a significant portion of the state. And we're hoping that that entrenchment of these programs will really help us convince the state of the need to really give us the funding that we've requested that could be dispersed to all the counties to ensure compliance with ILS family court caseload standards. And so that's the goal. It's not only to keep these programs fiscally sound, but also give us a leverage point from which to work with the state on increased funding for family court representation.
I'm assuming that part of that is strategic, given that we didn't get.
Yes.
Okay.
Yeah.
Makes sense. And just to be clear, sorry, this may seem like an elementary question, but the fourth family defense, you said that would go to 18 or 19 counties that are not currently receiving, which would then extend. Okay, I just want to clarify.
That's the goal. Yeah.
Yep. Okay.
Well, there any thought to making the amounts variable based on need in a particular county, or size of the county, or some other measure like that?
Yeah, we have given a lot of thought to that. It would be very difficult with how the current competitive process works to do that. And so, and also very difficult to sort of manage, how that would happen. That's part of why we want enough funding to disperse to the entire state, because then we can use that more formulaic approach, based on basically caseload need.
Yeah.
But I can say that, there's no county that wouldn't benefit in a very meaningful and significant way from having $250,000 a year for family court representation. So, essentially it's for some counties, for all counties, it's meaningful. For some, it's not anywhere near enough. But it's a good start.
But you're thinking of it strategically as planting a flag, basically, and, right? It's not a permanent source of funding.
Yeah, it's a good way to put it.
Are there any counties that have consistently not applied, and does that kind of put them on your, I'm sure everything's always on your radar, but
Yeah.
make you more aware of perhaps their lack of understanding of some of these?
It's, that's a really good question. And yes, there are counties that haven't applied and, we're not in the RFP process. And when we're outside the RFP process, we are permitted to tell counties that this opportunity will be coming down the pipeline and to help them understand what the opportunity is and what resources may be available to them to, understand how to submit a proposal. And so we're going to be doing that, and that's perfectly permissible to do. Obviously, once an RFP is issued, we're not permitted to have communication with potential applicants about the RFP process. And we're very vigilant about that. But, for the counties that haven't applied, our sense, based on what we know about these counties, it's not because they don't need the funding or don't want it, but it's really because counties are struggling with the fiscal infrastructure needed to do something that's, something like submit an application in response to an RFP. This isn't something that counties necessarily have a great deal of expertise and experience in doing. And so, some of it is trying to, connect them with places that, other counties that have done it before and could give them some guidance on how to do it. And also just, trying to make the RFP process itself, fiscally sound and, have accountability, but not needlessly difficult or overwhelming to do. And one of the things that emerged at the April staff meeting, and this is where I really appreciated having Chris DeBolt on our board, is he, from a county perspective, said, last summer, ILS issued 3 RFPs, and that was a lot to do at one time for the counties. And the counties really struggled with that. So, this year we anticipate issuing just the 1 RFP, and we're hoping that that will allow the counties to devote the time and resources needed to respond to that RFP.
So, just question, following up on what Jill said, I was just gonna say that I know that part of this is having the expertise and the bandwidth in order to do this, and given infrastructure issues, how to present that in a way that's successful. So that's one issue. The other thing is I just came off of 2 access to justice meetings involving family law. Particularly, one is, and we're struggling in Onondaga County, so I'm just speaking about Onondaga County at the moment. For a family law representation, part of that is the salaries.
Yeah.
So this money is desperately needed. But what I also wanted to let you know about, and maybe we can, spread the word, especially as it relates to family law defense, is we're trying to think of ways, and we're thinking about possible programs that we can conduct with law students to drum up interest in the family law area. And not just from the law school, but practitioners, judges, that kind of thing, because as you all know, family law is not for the faint of heart. So, and I honestly, I fell into it. It was the thing that, kind of stoked the fire in my belly, but trying to convey that is easier for me in a law school, but right now, given the salaries, it's really difficult. So there are a lot of students that look at family law and they go, no way am I going near that, especially given the pay that I would receive. So I just offer that as a possible incentive because we're looking at it, both the family law and domestic violence subcommittee of our Access to Justice in the Fifth Judicial District, as well as the whole Access to Justice Committee in the Fifth Judicial District. So it's part of what we're trying to do to promote this.
Yeah, no, and I think, some of how we would, if we got enough funding to disperse the family defense funding statewide, we have the experience doing the Harrell Herring settlement statewide and the lessons we've learned from that. And what you said about, getting people interested in doing this work and passionate about doing this work and the very many different ways to do it, including reaching out to students when they're still in law school. For our defenders who are using the statewide money in criminal court, that's where they've achieved success. Is really getting those new attorneys and instilling in them a passion for the work. And so I agree with you that we'd have to, take that into account with the family defense funding as well. And of course, salaries it's a persistent issue.
Students who practice in the clinics, right, under supervision, so they don't get paid for that, do they? They just get credit. So that's a savings.
Yeah. There's not a lot of the law schools, at least in New York, particularly in upstate, have cut back on their clinical programs. So we've started to create, sort of have some other ideas about how to attract law students. And some of it is making money available to pay interns, because it's not the full salary of a defender, but you can still have somebody there. They need the money. It's attractive to them. So
Sort of stipend.
One thing that's being done is that students are now family court is being included more heavily in terms of externship judicial placements. Used to be in the past, and that's being promoted again. So
that's another,
One thing the Monroe County Public Defender's Office did was, it used to be that we could only hire people who were admitted because they had to go to court. But with the ILS funding, there was additional money made available, so they started hiring incoming classes of law grads who weren't admitted and giving them the opportunity to take the bar. But that has really, they have big classes coming in now, and they never had anything like that before.
I wanted to see if Vince had any questions or comments.
No, I don't. I appreciate the information about the allocations. They seem appropriate to me. I didn't have any questions, so thanks, Patricia.
Well, then if there's no further discussion, we need a motion in a second.
Second.
Okay, all in favor? Great, that carries. Thank you. Next, we get an update on the statewide appeals. Here.
Oh, thank you. So I'm Claudia Troop. It's nice to be here today to report on the first year of operations of the Statewide Appellate Support Center, with the caveat that I can take absolutely no credit for any of the work that was done in this report, because as you know from the last board meeting, I just got here. That said, I'm thrilled to talk about the work that was done and that we will be doing. So as by way of background, the State Appellate Support Center began in October 2022. It is part of the support centers Patricia just mentioned, the regional immigration assistance centers throughout the state, and also the Western Regional Support Center. It's one of those centers. While it has appellate in its title, it's a little bit of a misnomer because we support attorneys across the states at all aspects of litigation, from indictment through post-conviction. And it is, the expertise of our staff, however, is centered in appellate and post-conviction litigation. We have decades among our staff of experience working in post-conviction, in the post-conviction realm. So as I was reflecting on our first year of operations, the Court of Appeals decided People versus Watkins, for those who are not as familiar with the case as some might be. In Watkins, the issue before the Court of Appeals was whether counsel was ineffective for failing to request a cross-racial identification charge prior to the Court of Appeals ruling in People versus Boone that such a charge was necessary if supported by the record. And the case was real. I had worked on the case in my prior life, and so I followed it very closely. And what was interesting about it is there was a lot of disagreement among the court, the majority, and the dissent about whether this was constitutionally ineffective assistance. But what I found most interesting, not to be too flattering of you, was Judge Wilson's concurrence. And in Judge Wilson's concurrence, what he said was that while we are focusing in this case, as we do in all ineffective assistance cases, on constitutionally effective assistance, that standard is really very low. And people facing a loss of liberty or a loss of family integrity are really entitled to more than constitutionally effective assistance. They're entitled to excellence. And so what would excellence have looked like in the Watkins case? Excellence would have meant that that attorney had the opportunity to read the CJI and the footnotes of the CJI to realize that there was a support for the charge, would have had the opportunity to read the Justice Task Force report about the importance of cross-racial identification as contributing to wrongful convictions of the actual system, would have had a chance to talk to his colleagues about the burgeoning areas of law, would have known about the Boone Lee grant and actually maybe watched the argument to see that the law was soon going to change. And when I've been speaking with practitioners across the state about the concurrence, what I've heard is nobody has the chance to read the footnotes. And that was the whole point, is nobody has the chance to read the footnotes because everybody is dealing with large caseloads. But at SAS, we are in the unique position of any support center across the country in that we don't have case-related crushing burdens. And so we can read the footnotes. Our staff reads the footnotes. We read the decisions. We read the commission reports. And we watch and track the Court of Appeals litigation and watch the Court of Appeals arguments. And our mission is to take that deep knowledge and experience and transmit it across the state. And so how do we do that? We do that in 3 ways. We do it by creating resources, by conducting trainings, and by doing individual consultations. I'll just touch on each of those a little bit. In the first year, SAS staff reached out across the state in conjunction with our Appellate Defender Council, who's a group of 30 appellate defenders from across the state who act as advisors to us, reached out across the state and asked people what would be most helpful to you in your practice. And from that survey, we received 164 responses from attorneys across the state. And based on that, we started creating resources for the most common issues that come up in appeals. If you are privileged enough to operate in a very well-resourced office, you have access inevitably to a brief bank of many, many cases and statements of law. We're trying to replicate that for people who do not have access to that. So some of the resources that we've created in the first year included guilty plea appeals, waivers of the right to appeal, excessive sentence, or 440 materials in both to set aside the motions to set vacate and motions to resentence, and DBSJA guidebooks and principles. Another resource we provide, which I know how helpful it is as a practitioner who relied on it before I came to ILS, is our decision of distress. Every week, SAS attorneys read every reported case in New York State, trial, appellate, Court of Appeals, and they summarize the most impactful cases and link not only to the stuff, we have summaries, we link to the actual decisions, and we link to the oral arguments. And we distribute those through our listservs, both on the family, and this is family court and criminal. And we distribute those across our appellate website as well as our family court listserv. So people getting that is a really easy way for people to be updated on the state of the law. So those are our major resources. We'll continue to develop them going forward. Our trainings in the first year, we pioneered an intensive brief writing training where people attended lectures during the morning and then broke out into individual groups in the afternoon to work one-on-one and in small groups to improve their brief writing skills. That program was replicated in Nassau County in the second year, and we hope to replicate it again and perhaps move it up to Western New York. And we hope to expand it to include appellate advocacy skills. Or advocacy skills, so that people get training on that. We also, in the first year, worked with the regional immigration assistance centers to put on a training in New York to train pro bono counsel to help non-citizens who are facing deportation based on past criminal convictions and to increase access to counsel for people in those areas. So those were our trainings in the first year. And then the third piece that we're working on is consultations. And consultations are really exciting. And one of the revolutions of the first year was what an appetite there is for this type of service across the state. So we created an intake form, which people can access from our website, where attorneys across the state can write in and request a consultation from one of our staff. In the first year, we received 120 requests for consultation. In the 7 months since this report was issued, we've received over 150 requests for consultation. We expect to more than double the consultations we did this year. Consultations, you can see in the report where they come from, the requesting counties, type of practice areas that they come from. They range the gamut from simple, how do I file a late notice of appeal, to complex, where we're working on a 440 investigation and motion, and then hearing with the attorney and partnering with them to provide guidance. And it is really something that we think has a lot of potential and has created a lot of excitement among practitioners across the state. Our mooting program has also been well subscribed to. A highlight this year was we mooted somebody who was appearing for the first time in the Court of Appeals. I think it might have even been her first appellate argument in People versus Bay. We conducted a number of moots of that practitioner, and we're very gratified to see that she knocked it out of the park in front of the Court of Appeals, resulting in a really great decision. That program continues to be very well subscribed to, and we hope to continue it with more vigor coming up in the next year. So that is a summary of what we've done the first year. I want to touch on what we hope to do in the year to come. We are going to be focusing on the promise of an interdisciplinary model to work towards excellence in defense across the state. The reason why we want to focus on an interdisciplinary model is because we think it has the potential to do several things. First, outcomes have been shown to be better when you are combining the expertise of different people in formulating a defense strategy. So if you have a mitigation or social worker specialist at the beginning of the case, in addition to an investigator, and in addition to a defense attorney, outcomes tend to be better. Also, and as importantly, clients tend to feel more heard and more respected, and communities feel better served. And also, importantly, it has the potential to decrease burnout, because if attorneys are not being asked to run in every direction, every which way, we have the potential to have younger attorneys last longer, which is really critical for increasing the quality of representation across the state. And burnout is a real problem in family and criminal defense, as anybody who's practiced can tell you. Having a strong stomach. And so we are hoping, so for example, next week at the ACP Summit in Albany, our interdisciplinary team consisting of an appellate attorney, our investigator, and our mitigation specialist will be presenting to the panel at the summit about the benefits of interdisciplinary practice from the beginning of the process, whatever form it is, through post-conviction. And we are going to be adopting that model in our resources, our training, and in our consultations. So we have recently put out materials from our mitigation specialists about trauma-informed interviewing and effective mitigation storytelling. Those are resources that have garnered a lot of interest among our community and have the potential to really increase the mitigation practice that's going on across New York. We've also started doing trainings that focus on the interdisciplinary model. We recently did a training on DBSJA resentencing in Dutchess County, where we brought together investigators, mitigation specialists, and attorneys to talk about how this approach can benefit a DBSJA resentencing hearing, which are incredibly resource intensive and complicated. So we hope to do that through across the state. Our investigator is starting we're very excited about this, a standards group to create standards in New York State for the investigation community with the hope of creating more community, fostering more excellence in the investigation function, and also creating more of a pipeline for people to be able to get trained as investigators and go out to offices, because a good investigator is hard to find. So that is what we are doing. The last thing I want to focus on as far as the upcoming year is access to counsel. New York is one of only 2 states that does not guarantee the appointment of appellate counsel after somebody is convicted of a crime. People have to reapply for and show that they are entitled to mandated representation. And people struggle with that and continue to fall through the gap of that's created by our statutory scheme. So we have recently convened a special working group of the Appellate Defender Council to talk about creative ways we can brainstorm about this problem. In addition to the problem of there being a lack of panel attorneys in the 3rd and 4th departments. And whereas in the city, there is no shortage of institutional providers, there are less panel attorneys upstate. And so the rates have been increased, but unfortunately, we have not yet seen an uptick in panel participation. So this new working group, the first call is on Tuesday or Wednesday, is going to be focusing on how do we increase access, because you can't have excellent counsel if you don't have counsel. And so that is really what we're going to be focused on. In closing, I just want to ask some things of the board. First, if you hear of anybody who's struggling with an issue, a legal issue, and could benefit from our services, send them our way. We are working to get the word out, and we have been successful, but the more people know about us, the more we can help. Second, if you know of anybody who wants to join our mission, who is committed to improving the quality of mandated representation across New York, send them our way. We are looking to hire people, and we are always interested in hearing from people who want to join us. And third, if you wake up in the middle of the night with an incredible idea about how to improve the quality of defense and mandated representation, and something that staff's going to do, send it my way. I am always so interested to hear other people's opinions. No matter how long you're working in this realm, you really need to hear from everybody to do the work. And so I'm really excited to be here and to take the helm of this project, and I'm hoping to have great things to share with you next year. So thank you. Any questions?
I'm curious what fraction, if you can estimate, of the requests you get are at the trial level, not the appellate?
I would say it's probably around 20%. And that is things like people, and it's great. It's situations where people will call in and say, I'm doing a 4th Amendment claim. I'm dealing with a car stop. Can you walk me through every stage of it? And that is something that we really at the appellate level have a lot of experience in. And at the trial level, it can be a little daunting. So those kinds of.
So I'm wondering a couple things, I guess. One is if the name is misleading a little bit, and you might get more requests if we're named differently.
I feel like we've just adopted SAS.
It
It's like the branding, you know, we're not SAS anymore, no, something else.
And then,
But I agree.
what if anything do you do to make it clear to people that even if it's not an appellate issue, you'd be happy to help them?
Sure. So that's a great question. We're going out virtually to various meetings. So for example, next week, we're going to something called the Wednesday WAG at the Westchester County Assigned Counsel Plan, and we're doing a presentation about the services we're doing. We also have something in the works to go up to the Portland Public Defender Office and meet with them. And we're going to be increasing that to do virtual. I mean, New York is such a big state, as anybody who's visited all the prisons knows. And we're going to be going across both virtually and in person to get the word out.
Part of the reason maybe the whole reason I ask, is I see a lot of cases where an argument that's made on appeal was not preserved.
Yes.
And I also see a lot of cases where I can think of a really good argument, it hasn't been made at all.
Yes.
And if you don't make those at the trial level, you're done.
Right. Right. And we do want to do training on preservation. I mean, I've been training on preservation, I think, for 20 years. It is one of those topics that just doesn't seem to I think it's because it's so fast paced at trial, and as appellate attorneys are always like, well, why can't you just preserve it? And it's like, you have 30 different things coming at you and you're concentrating on not necessarily preserving for appeal. But I do think that that is a real problem in appellate practice and a constant source of frustration for appellate
Right,
practitioners.
exactly. It's the appellate practitioners, I think, the greatest understanding of the need to preserve more so than, I mean, if you're a seasoned trial practitioner, you would know that.
Right.
It's done a couple times.
I was speaking to somebody at Legal Aid in the city yesterday, and when I was starting out, we had young appellate attorneys go out into the trial court offices and second seat, and it was such a wonderful program. Yeah, they were mad. The trial judges hated it. They were like, you would take a 3-week trial, and it would be a 6-week trial. I was like, I'm objecting to the use of the interpreter, and the judge would be like, what? But so I am trying to get that. I'm trying to get that reinstated, so that there can be more cooperation among the trial and appellate offices, because the criminal process it's one full process. It's not artificially, the trial and the appeal. It's all, a conviction isn't final until the appeal is final. And so we have to start thinking about it as an integrated system, and representation is integrated.
When I was at the Capital Defender Office, we, as soon as a death notice was filed, we had, you euphemistically call our appellate attorneys our geeks. We had a geek. Say the term of endearment.
It's like the geek spots.
Yeah, but I think in a lot of ways, like when we talk about an interdisciplinary approach to representation, to me, at some point, what we're going for is everything that Claudia described and an appellate lens as part of the team. Yeah. Mhm.
I think that's wonderful, and I, also park myself and Brian Schiff in our Judubin's office throughout my career, but I think maybe folks, just trial level attorneys, aren't as aware as you're describing it, and I wonder if one of the things that could be done, and this is kind of like in the weeds, but with the case out updates that you put out, just in bold letters at the top, trial attorneys can call us for questions about their cases, although you have to figure out how to do it so you're not inundated with like, do I have to go to court on Monday?
Right. Yeah. I think that's a good idea.
Yeah, no, it's, the statewide appellate support center is still relatively new, but I think that, there was thought about outreach, but also be careful about delusion.
Yeah.
And I think Claudia's working at striking that balance, and I love the fact that there's, active outreach and just going to places, because I think presence, whether it's in-person presence or even virtual presence, it's really big difference.
Yeah.
Or maybe in some of these trainings, if you could have like a senior trial attorney and an appellate attorney present together, right? And especially for those appellate attorneys that work in offices that also do trial work, you can start getting the word out. Because I know I've had trials where I know I'm done at the trial level. Like I'm thinking full appeal. So, and there was one immigration case that I had, and I'm not an immigration attorney, where it was, we're not going to win at the trial. So it was all about how to preserve. So I went to immigration trial experts. So
That's true for mitigation too.
Yeah.
I've had the fortune of working as a mitigation specialist in cases where I knew that I was not talking to the trial judge.
Right.
This was for appeal.
Yeah.
Great. Thank you. That's great.
Great presentation.
The ideal, the aspirational.
Yeah, it's, sometimes it just feels like there's just so much to do, but you just have to I was talking to somebody, I'm like, you just have to chunk it up.
Yeah.
You can't just look.
People like you to do that for us.
Chief, could I ask a question?
Please.
Yeah, excellent presentation. I'm really glad to hear all the work that you're doing. The biggest issue I see, particularly at the intermediate courts, when I go to the fourth department, is they'll have the criminal appeals first, and more than half of them are submitted. There's no argument, and that's such a signal, I think, to the judges about what the appellant thinks of the argument. And I wonder if that's something that you're working on, encouraging the defenders to do oral argument, because you never know, there may be a judge who has a question, you may be able to convince someone, you may learn something for your next case. So I wonder if that comes up at all.
I had some really interesting conversations yesterday with providers, and I think something that we're going to be doing, our standards say that you should argue every case unless there's a strategic reason not to argue it. And I think we really have to start going out and training on the standards. And I think that could be a great service, at least to the institutional providers, because it's hard for it to come from management without it meeting resistance in offices that are newly unionized. And so we have a number of appellate offices across the state that are newly unionized. And what I'm hearing is it would be better if this message about you need to be arguing cases, you need to be triaging your cases to get them to court based on need, who's incarcerated rather than just first in, first out. These messages need to be given, and we're probably the best suited to give them. And so we've been talking about doing trainings on our standards in a variety of ways. And I think it's important that we follow through on that. It also makes me
I think the standards say not only there's a strategic reason, but that you discuss it with your clients
right.
as well, because that, you know, that, and having that conversation sometimes convinces you, yeah, I really need to go to court to make sure my client is heard.
Yeah, definitely. I agree with you, though, that submitting a case on appeal, I can't imagine doing that. You know, so.
Do you think it'd be useful to have a Fourth Department justice like speak at one of these places and emphasize the importance of argument? And
Yeah, yeah,
because I bet a bunch of them would be willing to do that,
sure.
especially if somebody called them.
Yeah.
I had a case once that I read, and I was teaching it in my appellate class, and I wanted to see what the oral argument was like. It was 4 justices, and then there was 1 dissent. So it didn't automatically get to the Court of Appeals, and it never went to the Court of Appeals. But I was interested in what the oral argument was like. And I went and looked for, you know, because you can look online for the videotapes of them from the Fourth Department, and it was submitted. And I said, you know, the lawyer could have convinced 1 more judge and gotten a trip up to Albany out of this, but a real shame.
Yeah. Definitely a problem and something that we will want to focus on.
Great. All right. I think we're done with that. We're on to the office updates.
Yeah, so I'll lead off with just a few updates on staffing and personnel. Since our last meeting back in April, Claudia is the only new addition to our office, so we're very glad to have her as Director of Appellate and Post-Conviction Representation. We are currently interviewing and recruiting for a handful of positions, including several wonderful opportunities with the Statewide Appellate Support Center to further bolster Claudia's team, and that includes supervising appellate attorney position, appellate attorney for parent representation, an assistant appellate attorney, and in addition, and a special assistant for mitigation. In addition to those positions, we're also currently recruiting and interviewing for an assistant director of information technology to, you know, help us handle our growing IT needs as we grow as an office, as well as a criminal defense representation counsel who will be charged with working with the counties that are in ILS Region D, which are sort of the upstate Adirondack counties. So hope to have more updates for you on those positions at the next meeting.
And then I wanted to update the board on another initiative that ILS is taking as an office. And again, going back in history to 2015, late 2015, when I started at ILS, I was a 13th staff member at ILS. And at that time, ILS was responsible for dispersing $81 million a year. Fast forward to now, and we have 50 staff members, and our fiscal responsibility is close to a little over actually $500 million a year for disbursements. So as you can see, our office has grown dramatically, both in terms of the number of staff people that we have and our responsibility. You know, this has been a lot going on with the office over the past few years, and a lot of the growth in terms of number of people really have occurred over the past 3 years. So now is an opportune time for ILS to, as an office, to pause and to reflect on how our office culture is doing for our staff people, and how we are doing in our commitment to diversity, equity, and inclusion. And for ILS, diversity, equity, and inclusion means a culture in which diversity is welcomed and embraced and sought, where everyone feels they have a fair chance at succeeding, and where everyone feels that their perspectives, experiences, and approaches to achieving ILS's missions are valued. So we're devoted this year to taking that pause, doing that reflection, and starting a process, because we're not just going to see this as a one-time initiative. We're going to see this as the beginning of a process that endures, as we seek to make sure that we have a very healthy culture at ILS. And so we're starting this process with a culture survey. And we've retained a third-party vendor, Chrysalis, and they subcontract with Capital Human CHCI. I always said
It's the Center for Capital Human Innovation.
thank you, to actually do the survey, to conduct the survey. And doing a survey is a way to ensure that we get voices from everybody in our office, because we want to hear everybody's perspectives. And so, we're conducting this survey. We anticipate putting the survey out, and we don't put the survey out. We actually are very distant from the survey and the raw data. But that survey will go out probably in late June or early July. And we're hoping that this survey provides us a baseline of where our office is currently at in terms of culture and functioning. And that the survey produce, responses and ideas for what can be improved and how to go about doing it. We're very optimistic about this survey in terms of getting thoughtful responses and ideas, because this last year we actually did a sort of mini survey of people who had recently been onboarded and asked for their thoughts and insights on their onboarding experience. And I will say I was so impressed with those responses. We learned some really, sometimes it's hard to hear critical things about your office, right? But I was so impressed with every critical thing that was said about the office was attached to a suggestion. And so, I just am very impressed with the people who currently work for ILS. I've said before, I'm impressed with the devotion to our mission, to people's thoughtfulness, to people's work ethic. And so while I'm prepared for hearing things that will be difficult to hear, I'm also fully anticipating that, consistent with the past survey we did, they'll come attached with some really good suggestions. Now, what happens is Chrysalis, works with us in developing a final report. And this final report will include initial recommendations for next steps forward. And then, like I said, it's a process. We're devoted to the process continuing, for as long as it needs to be, and always having opportunities for checking in, to making sure that people feel that they're in a place where their expertise and their experiences are valued. So I just wanted to give you a heads up that we're doing that this year. We'll keep you in the loop as things go forward on next steps.
Can I just say, I think that's great,
Yeah.
first of all. And the fact that as a result of this mini survey, you got, and I'm going to call it feedback and not criticisms, right? So, and it might mean semantics to some, but I think it's really meaningful. The fact that you're getting that feedback along with suggestions signals that there's still a strong level of investment in the office, and that there's a sense of belonging that people feel willing and want to contribute. So,
No, and, you know, I was brought up, my parents are very involved in social justice issues and activism. And I remember going to protest with my dad and people, you know, yelling from the road, you know, love it or leave it, you know, and I used to say to my father, I don't understand, like, you're criticizing our country. Does that mean you don't love it? And he's like, no, it means I do love it. And you're like, that's, you know, that's, if you really care about something, you want to see it be the best it can be. And so that's sort of the attitude that we're having with this survey is welcoming the suggestions that people have and knowing that it's coming from a place of wanting ILS to be the best that it can be.
worst thing is silence.
So any other?
Well, that sounds wonderful.
Yeah, that's absolutely.
You'll let us know what, how it turns out.
Yeah.
Great. Well, unless anyone has anything else, we can entertain a motion to adjourn.
So.
All right, we're adjourned. Thank you.
Yeah.